If the political party with the support of other political party or other MLAs stakes claim to form a government and satisfies the governor about its majority to form a stable government, the governor cannot refuse formation of the government and override the majority claim because of his subjective assessment that the majority was cobbled by illegal and unethical means. No such power has been vested with the governor. Such a power would be against the democratic principles of majority rule. The governor is not an autocratic political ombudsman. If such a power is vested in the governor and or the president, the consequences can be horrendous. The ground of maladministration by a state government enjoying majority is not available for invoking power under Article 356. The remedy for corruption or similar ills and evils lies elsewhere and not in Article 356(1). In the same vein, it has to be held that the power under the 10th schedule for defection lies with the Speaker of the House and not with the governor. The power exercised by the Speaker under the 10th schedule is of judicial nature, dealing with the question whether power of disqualification of members of the House vests exclusively within the House to the exclusion of the judiciary, which is in Britain was based on certain practices of the British legislature as far as India is concerned. My Lord, it has been said, I'll skip that. My Lord, please see 166. The governor cannot assume to himself the aforesaid judicial power and based on that assumption come to the conclusion that there would be violation of the 10th schedule and use it as a reason for recommending dissolution. Lord, he also cannot refuse floor test.
But look at what the consequence of these observations in the present cases. The governor,
I earnestly request your Lord.
But we are since beyond those two paras, just those two paras. No such, the court says, the governor cannot refuse the formation of the government and override the majority because of his subjective assessment that the majority was cobbled by illegal and unethical means. Therefore, irrespective of what the governor feels or what somebody else feels about the fact that in forming a government with the INC and the NCP, you gave up a pre-poll alliance. It is irrelevant to the governor. This is a government which has been legitimately formed. All right, that's step one. Second, para 166 says that the governor cannot assume to himself the aforesaid judicial power and based on that assumption come to the conclusion that there be a violation of the 10th schedule. So it was alien to the governor's mind that these 34 would have to be excluded from consideration because they have incurred a disqualification under the 10th schedule. For the governor, he has to treat these as part of the Shiv Sena, irrespective of what their internal differentiation is. Therefore, he cannot now say that this 34, the letter which these 34 have given me, is a ground for shaking the faith of the government or the trust of the government which they have. He has to take these 34 as forming a part of the Shiv Sena legislature party.
Now let me show.
And if they are a part of the Shiv Sena legislature party, where is there any ground to say that, well, there is now a change in the position of trust in the House? Prima facie, at least, for him.
Now, let me show the judgment of the High Court, which was dealt with by Bomai judgment. Your Lordship's, my Lord, very right concern, my Lord, comes in the form of Mr. Sorabji's arguments, which was rejected, and your Lordship in Bomai did not accept that rejection. Kindly, my Lord, allow me to place, my Lord, that High Court judgment, my Lord. Because when we cite Bomai, my Lord, we generally don't see the High Court judgment, my Lord. Kindly see, my Lord, para 32. And this would be, my Lord, an answer. And, my Lord, please, again, my Lord, I am requesting, please examine the law as agnostic of the facts right now. And thereafter, my Lord, I will assist your Lordship on the facts. What is the law? What is the power of the governor? What are the contours of power? What are the limitations? Lord, please come to para 32 at 2472. My Lord, the right hand side top is the pagination.
1 minute.
2472, my Lord, para 32. Lord, this can be, my Lord, my answer.
Para 32.
32, my Lord, at page 2472 of this judgment. Lord, left or right hand side top, my Lord, is pagination. May I read, my Lord? Your Lordships have got. Mr. Soli Sorabji also contended, this is his argument before the High Court, my Lord. that the factors like alleged unethical methods adopted during the formation of Janata Dal, expansion of cabinet, horse trading, and atmosphere getting vitiated are not only vague but have no rational nexus at all. The question of failure of constitutional machinery. The learned counsel also laid, my lord, kindly come down, my lord. Anti-defection law, my lord, it says, I'll just read fully. The learned counsel also laid great stress by contending that governor, by acting upon the letters given by 19 legislators, had circumvented the anti-defection legislation, the primary aim of which is to discourage the toppling game by legislators by changing their loyalties, and by acting upon those letters, the legislators were permitted, in substance, to play the game of toppling the ruling party, ruling ministry, without incurring the consequence of anti-defection law, because if these legislators had withdrawn their support in the House and voted against the ministry, they would have incurred disqualification under anti-defection law. Reliance upon these letters is contrary to the underlying purpose and the essence of anti-defection legislation, and therefore illegitimate and prohibited. Kindly mark this. The learned counsel buttressed these arguments by contending that if the floor test had been held, the legislators would have written letters, who had written letters might have changed their mind for several valid reasons, i.e., change of the style of functioning of leadership, change in the leadership, realization for maintaining party unity, unwillingness to incur disqualification under anti-defection legislation, and 5, not giving a pretext for imposition of precedence rule. In support of the contention that the floor test has always been recognized as the legitimate and relevant method, Sri Sorabji relied on the judgment of Orissa High Court, so and so, so and so. My lord, he was insisting that please allow floor test, because that's what the law says is the only test. That's what we call dance of democracy, is on the floor of the house, not outside. And the governor cannot go beyond a particular point. Look, this was rejected by the High Court, my lord, at para 54, 34, page 2475. May I read, my lords? Mr. Sole Sorabji had made pointed reference to the 10th schedule, that is anti-defection law, for bringing home this point, that the factum of the withdrawal of support by 19 legislators was wholly irrelevant. This argument was advanced to prove his point that in
34.
I'm sorry, my lord, page 2475, para 34. I'll read again, my lord, for my lord Justice assistance. Mr. Sorabji had made pointed reference, this is the finding of the High Court, pointed reference to the 10th schedule, i.e. anti-defection law, for the bringing home his point that factum of withdrawal of the support by 19 legislators was wholly irrelevant. This argument was advanced to prove his point that in the context of anti-defection legislation, floor test was the most relevant, legitimate and surest method to determine whether the Council of Ministers headed by Sri Bomai commanded the majority in the House or not. We are afraid we are unable to agree with this submission of the learned counsel. The introduction of 10th schedule in the Constitution has not in any way affected the exercise of powers under Article 356, nor has it amended Article 356 in any manner. The amending body which inserted the 10th schedule to the Constitution had before it the several decisions, especially the Rajasthan case, as to the scope of Article 356. There is a presumption that the law-making body was aware of the existing interpretation, and the court said that no, he should have kept Schedule 10 in mind while exercising powers under 356. Now, my lord, please see how Bomai judgment deals with this. Lord, it was pointed out that para 397, my lord, was read out of context, my lord, to show. Lord, kindly see, Lord, Bomai is, my lord, JC volume 2, PDF page 516.
516?
Yes, my lord. Your lordships, my lord, in the judgment of Justice Jivan Reddy, my lord, at page 516, my lord, para 389, formulates the question. Volume 2. I'm sorry, my lord, my allotted time is over, my lord. Kindly allow me, my lord. I am not repeating anything, my lord, and
Certainly.
The 389, my lord, your lordship says, I'm not reading all questions because they are not relevant for the present. Only question number 6. A special bench of 3 judges of High Court heard the writ petition and dismissed the same on the following reasoning. Please come to 6, my lord. The introduction of 10th schedule of the Constitution has not affected in any manner the content of power under Article 356. Lord, the argument of Mr. Sorabji was that all right, why you are not concerned with 10th schedule. Direct floor test to be held. Don't dismiss the government under 356 straightway. And, my lord, the court, my lord, thereafter records, my lord, page, my lord, 393, my lord. I'm sorry, my lord, 397. In this context, my lord, the court examined this, my lord, that it is wrong. The governor should consider before removing the ministry, before not installing the government and imposing precedence rule, you should have given the floor test. And that in that context, my lord, 397. Please see, my lord, 397. May I read? We are equally of the opinion that High Court was in error in holding that enactment or addition of 10th schedule to the Constitution has not made difference. The object of 10th schedule is to prevent and discourage floor crossing and defections, which at one time assumed alarming proportions. Whatever may be his personal predilections, a legislator elected on the ticket of a party is bound to support that party in case of division or vote of confidence in the House, unless he is prepared to forego his membership of the House. The 10th schedule was designed precisely to counteract horse trading. Except in case of split, a legislator had to support his party willy-nilly. This is the difference between the position obtaining prior to and after 10th schedule. Prior to the said amendment, the legislator could shift the loyalty from one party to the other any number of times without imperiling his membership of the House. It was as if he had property in the office.